Good morning, moderator. Are we ready to go?
Yes, I've been told that board member Cruz is at the Sacramento location, so you have your quorum.
Okay, great. All right. Well, good morning, everybody. Today is the licensing committee meeting, and this meeting of the Board of Chiropractic Examiners Licensing Committee is being held by teleconference from the following locations: Department of Consumer Affairs, the Stanislaus Room, 1625 North Market Boulevard, Suite S-203, Sacramento, California, 95834, and at 1165 Park Avenue, San Jose, California, 95126. The date is Friday, August 25th, 2023, and the time is 11:01. The board's paramount responsibility is to protect the health, welfare, and the safety of the public through licensure, education, engagement, and enforcement in chiropractic care. Members of the public may address the committee during the public comment session. Public comments will also be taken on agenda items at the time the item is heard and prior to the committee taking any action on said items. Those who would like to provide public comment will be limited to 3 minutes unless in the discretion of the committee, circumstances require a longer period. Members of the public will not be permitted to yield their allotted time to other members of the public to make comments. Individuals may appear before the committee to discuss items not on today's agenda. However, the committee may not discuss or take action on these items except to decide whether to place the matter on the agenda of a future meeting. Please be aware that this meeting is being recorded, and please turn off or silence your cell phones, and we will now take roll. And Ms. Cruz, will you take roll? And I think we need to mention our location during the roll. I'm not sure.
Sorry. Okay. Oops, am I here muted? Okay. Sure, I'm unmuted. Sorry. I just have to adjust here. There we are. All right. We'll start with Dr. Daniels.
Present at 1165 Park Avenue, San Jose, California, 95126.
Jeanette Cruz, present at Department of Consumer Affairs, Stanislaus Room, 1625 North Market Boulevard, Suite S-203, Sacramento, California, 95834. Roll is called. Quorum set.
Great, thank you. Are you guys hearing, is the volume okay on my side?
Yeah.
Okay, all right. Okay, so moving to agenda item number 2, review and possible approval of the committee meeting minutes from May 12th, 2023. And so at this time, I'd like to open up, is there any comments from the committee on the meeting minutes?
And then for me?
Okay, yeah, I felt that in reviewing the meeting minutes that the items that were discussed were accurately displayed. So I would like to make a motion to, should I open up to public comment first before the motion?
This is Sabina. Good morning.
Hi.
You can do public comment after a motion in a second,
Yeah, okay.
and the motion will be to approve the meeting minutes of May 12th, 2023.
Okay, perfect. So I make a motion to approve the meeting minutes of the licensing committee's meeting, May 12th, 2023. And is there a second?
I second.
Okay, and moderator, can you open this up for public comments?
Thank you, Madam Chair. I've opened up the Q&A panel, so if any members of the actually, first I should ask, are there any members of the public at the Sacramento location?
No.
Okay, and how about our San Jose location?
No, no public members.
Okay, all right, then if any, I do see that we've got people in WebEx with their hands raised, so you may request to speak for public comment by raising your hand or by typing comment in the Q&A field in the lower right-hand corner of your screen. Please note you have a 3-minute time limit. I'll give you a 15-second warning when your time's almost up, and we'll begin with call-in user number 2. Call-in user number 2, you should be able to unmute yourself. And that's star, there you go, you're unmuted.
Salute, this is Falcon Lumont, student intern from Life Chiropractic College West. Thank you for compiling the minutes of the previous licensing committee meeting. I did know that, well, I don't agree with the draft of it, not for what is there, but I might have missed what, like, where it said, well, the agenda minutes had agenda number 4 for the rule edit for the college curriculum, and for whatever reason, the agenda item for that isn't on today's agenda. Where was it said in the previous, in those May 12th minutes to remove the rule edit as its own agenda item, and where was it agreed to move it to the board's licensing? I'm happy that it's still being discussed, at least in the board's licensing program agenda item, but it seemed like there's progress there, but it still got demoted off of its own agenda item. So I don't know where was that ever spoken about in the previous minutes on May 5th, or on May 12th. So I don't agree with the approval of the May 12th minutes because of the removal of the agenda item.
Moderator, were there any other public comments?
Thank you. I was told that calling user number 2 is Falcon, but I see Falcon with hand raised. So, okay, the hand's down. So no other public comments. Shall I close the Q&A panel?
Yes, please.
Okay, it's closed.
So thank you for your comments. This motion is simply to approve what was said during the meeting, and that's what contains in the meeting minutes. So at this time, I'd like to take a vote to pass the motion.
Dr. Daniel?
Yes.
Jeanette Cruz? Yes.
Motion passes. Ms. Walker, anything to add?
No, just to briefly respond to the public comment. The agendas are set by the committee chair in collaboration with staff, and the item the status of that regulation that we're working on will actually be addressed during my report in agenda item 3.
Perfect. Okay, so if there's no other concerns, I'd like to move on to agenda item number 3. And Ms. Walker, can you provide us with an update?
Yes, and they're going to navigate real quickly to just a brief slides just to keep us on track for my update this morning. I'm going to keep it rather brief because we do have 3 discussion items to get to after my update this morning. Beginning first with legislation. These bills we last discussed at the board meeting in July. We've got 2 that directly affect our licensing program. The first bill that affects us is AB 883, which has to do with requiring boards and bureaus within DCA to expedite licensure for applicants who are enrolled in the United States Department of Defense Skill Bridge program. That bill is currently making its way through the legislature. It's in the Senate Appropriations Committee, and it's scheduled for a hearing on September 1st. The second bill that we have is SB 372, which is Menjivar. That has to do with the Department of Consumer Affairs handling of licensee and registrant name and gender changes, specifically requiring that under certain circumstances that those requests be treated confidentially and that someone's prior name be removed from the board's public records and displayed on the website. That bill is also making its way through. It's currently on the Assembly floor, and if it passes through the Assembly, it's going to have to return back to the Senate for concurrence on amendments that were made earlier this summer with the bill. Those amendments are the ones that DCA actually collaborated with the author's office on to just come up with a solution that would work well for the DCA boards and implementation. Where staff is really at with both of these bills is, in addition to monitoring them, we are preparing for implementation if they were to pass. If the progress that they're making, it's very likely that they may be signed into law. So we're beginning our initial preparations on how we would implement those. First, AB 883 would require that we update our initial license application to inquire if somebody is enrolled in that program, and then update our licensing processes to ensure that we expedite those applications if they meet that criteria. And the second one for SB 372, that one's more of a collaborative effort with the Department's Office of Information Services for ensuring that we can appropriately withhold certain records from our DCA search public-facing website. So collaboration is underway on getting both of those bills implemented if and when they pass later this fall. Moving to the next slide, I also wanted to provide an update on our regulatory proposals that we have that affect our licensing committee. Apologies, the text is a little bit small, but what I wanted to really show was our continuum of where we're at with the different regulatory proposals and what's next. So we do have quite a few that are in our concept development phase. We've made quite a bit of progress over the last year in identifying what that workload is and bringing them to committee for discussion. And we're developing those concepts so that they're strong, that when we get to the board level, we can have effective language that we can move forward. One of them is a cleanup regulation that staff just needs to find the resources and the time to dedicate to going through all of our regulations and cleaning them up and ensuring that all references to fee amounts reflect our current fee schedule. So that's something that we'll be working with our legal counsel to do this fall. We've also got the implementation of temporary licensure for military spouses and partners. That's another bill that the requirement became effective July 1st of this year. We've implemented the online functionality to be able to accept the applications. We haven't yet received one, which isn't all that surprising because we weren't anticipating a high volume, but we do need to come up with just some cleanup language in our regulations that define the process for obtaining the temporary license. And as I mentioned at the last meeting, the biggest challenge is the fact that our regulations don't accurately or thoroughly reflect the process for a permanent license. So we need to tackle that as well as part of that concept. Then we have the regulation that was referenced during the prior public comment. There's the Chiropractic College requirements, and that's the requirements on the institution as well as the curriculum requirements. It's a pretty comprehensive effort that's been tasked with the licensing committee of really updating those regulations that have been in effect for quite some time. Over the summer, especially spearheaded by Dr. Daniels, there's been a lot of work behind the scenes collaborating between staff and Dr. Daniels on that concept. She's had numerous discussions with various stakeholders, and we're really working on developing that language so that when ready, we'll bring it back to the full committee for discussion. The other item to note when it comes to the Chiropractic College curriculum regulations specifically is we have two reports that are coming out this fall and early next year that are going to also affect that effort. The first of which is the Council on Chiropractic Education, CCE, is going to be releasing their updated accreditation standards this fall, which are largely going to inform where we go with those regulations. And then also DCA's Office of Professional Examination Services is assisting us in developing our next occupational analysis of the chiropractic profession. Really our next steps on that is to conduct a survey of our licensees this fall. And then OPES is planning to release that final report in early 2024. So with that regulation, we've already done some groundwork in moving that forward, but those two documents, the CCE accreditation standards and our occupational analysis of the chiropractic profession, are really going to be key for us developing that final proposal that can move forward to the board. There's a few other regulations in the works. We have a pending Consumer Protection Enforcement Initiative proposal to implement the ability for us to order a physical or mental examination of applicants. We currently have the ability to do that for licensees, and this proposal would expand on that and then allow that same ability for an applicant. Staff is still exploring that, and we plan to bring that to the licensing committee, if not later this year, probably by early next year. And then later during today's agenda, we'll be discussing chiropractic practice locations and another CPEI proposal that had been started on requiring the display of license information and the fact that licensees are licensed by the board at practice locations. We're also working in the area of reciprocity and looking at what the licensure requirements are. And then really very early in the concept development is just looking at also how we handle inactive licenses. There's quite a bit of work. Really thank the committee for all of their efforts on all of these different concepts and all the discussions that we're having. We've got two regulations that have really moved to a production phase where we're getting them ready for public notice and really initiating the rulemaking phase. The first, that's where the licensing, my apologies, that's where the licensing and regulatory fees comes in. We have to draft that proposal. And then we also have the proposal about the address of record, clarifying what that means to file an address of record with the board, and then also adding phone numbers and email addresses to the board directory. So we expect that one to be ready and likely coming this fall to the notice period where we can start collecting public comments on that proposal. Before I move forward on that, are there any questions from the committee on our different regulations that we've been working on?
I have one question. It didn't have to be answered here, but I'm just wondering if there are any impacts to, for the reports we're waiting on from CCE and DCA, is there any impacts to any of our initiatives or objectives in the strategic plan? I wasn't sure if there's any interdependencies. I was looking for it at least really briefly just now, and so far it doesn't seem any, but I imagine it might. I would have at least it would be more, it would inform.
That's what I was gonna, that was gonna be my response there. It's really gonna help better inform the board and the progress on certain policy areas when we have an updated description of kind of the direction the CCE is going, and then also an updated description of practice of the different requirements and what they determine to be of the most importance within the chiropractic profession. So it's gonna inform our efforts, but it's not really going to affect them other than the chiropractic college regulations.
Okay.
Ms. Walker, I had a question on the Assembly Bill 883. I heard you on the figuring out how to expedite when somebody does apply and then updating our initial license application. I was just curious, and I think we're going to talk about it later, but how this bill relates to any issues of enforcement or reciprocity as far as licensing goes.
So this bill is, this one's actually pretty straightforward. What it does is by requiring that the board doesn't really have backlogs in terms of initial applications. But what it does require is that we expedite an application if somebody is enrolled in that program. So, you know, if you have applications that you received in that week, they go to the top of the stack. We already do something similar for, we're required to do that for military spouses and members of the military. So we already have the model. We just need to expand our criteria under which we would, they would qualify for that expedite. So there's not a lot of impact there other than just more of a relatively straightforward change to our application to inquire if they qualify for this program so that we can then flag them for that expedite.
Okay.
So it's not, this one specifically won't have any impact on reciprocity.
Okay. Yeah, thank you. I understand that better. And then on the Senate Bill 372, are there any legal ramifications for the board if there's an error So I have two questions in this section. So one, I was just curious if there's any legal ramifications as far as if the board makes an error, you know, in what they publish. What does that look like? Because some of the other cases that we've had with privacy information makes me think of that when I read this bill.
And I respectfully ask Ms. Knight to respond to that question, as it kind of talks about legal liability.
Yeah, good morning. That's a great question. I think I don't see anything in there immediately. I'd have to look at it's gone through a lot of different versions. So we'd have to look at the newest version. It has gone through a lot of really great improvements and a lot of concerns from all of the boards who have been giving the author's office input, including DCA proper. The good thing is that a lot of boards don't receive a lot of these requests. And so I think, obviously we're all human and errors are made, and software and the internet and, our programs are not foolproof. However, I don't think there's any, I'd have to look. The bottom line is I'd have to look, but the bottom line also is we don't receive a lot of these. And I think errors will be very few and far between because of that. We're not doing, 100,000 of these a year type of thing. So, but I'd have to look at the new version to see if there's any type of, punishment or penalty, if you will, for.
Yeah, that would be great because I have a little PTSD from a particular case.
Yeah,
and
I
so
know, everybody does.
yeah, so we don't do many, but it only takes one. So
Yeah, exactly.
So I'd just like to make note that that's one of my concerns of just,
And
go ahead.
there's still concerns about, how do you deal with a national practitioner database? There's still a little bit of loose ends that need to be tied up, I think, on how it might look in real life, and, how is Breeze going to, be updated to do it, So it's still a work in progress, and they have made some great improvements in the bill so far. They have limited the scope a little bit to help everybody out, because at first it was everybody, every situation. And so now we're much more focused. And so we'll have to take a closer look. And if we have an update at the next board meeting, we'll have to include that in our update.
Okay. And then kind of along that line, is there, and maybe it's irrelevant, but the what is offered to the public, or what is going to be shared with the public when they do contact the board? Is that sort of in the legal language of the bill?
Yeah, and because as a licensee, you have less protections, of course, as you, ask for. It's a privilege, not a right, right? So we would have to disclose the other information. I think that is in the bill exactly what would be. I just pulled it up in the entirety. But because we cannot just completely seal it and hide it forever like the courts can, right? When you go through that court order, they do seal that for those particular reasons. So, and fortunately, unfortunately, in our line of business, where it's public protection, and so the public does have a right to know that information. But it would be like contact the board. But those would be processes that would be worked out with the board, and I'm sure DCA will be providing some guidance to all the boards together, depending on what version of this bill passes, and then trying to help everybody out and how to deal with the new process.
Okay, great, thank you. And then Ms. Walker, I was just curious on the licensing and regulatory fees. It said the package is planned to be submitted in the fall. I was just wondering if we were on track with that. You might have said it, but I missed it.
We are on track with that one. That's actually a relatively straightforward package that we're trying to put together. It's similar to what we did with the repeal of the sponsored free healthcare, where it's a Section 100 change. It doesn't need to go through any committee or board approval, because we're just updating the change without regulatory effect to reflect the statute. So we just need to get that through our council and reviewed so we can get it filed with OAL.
Okay.
So we are on track
then-
with getting that done.
Okay, cool. And then it sounded like you're on track with the addition of the telephone numbers and email addresses as well.
Yes.
Okay, I didn't have any other questions with what you presented so far, Ms. Cruz.
No additional for me.
Okay. Thank you. Then I will continue on. I just wanted to provide a brief overview of what our fiscal year in review looks like as far as the licensing program. As far as our initial licenses, we're up slightly. We had a slightly higher number of Doctor of Chiropractic licenses issued during the fiscal year compared to in the past. And our cycle time is looking relatively good. We're hovering right around 6 weeks for the total processing time for an initial license application. And then as far as our corporations and our satellite certificates, really what we've observed during that fiscal year was a significant increase in the number of satellite certificates being requested. And we largely have been attributing that likely to the recovery coming out of the COVID-19 pandemic and licensees we had observed some contraction with the number of practice locations, and we're now seeing that expansion. And that's coming through with the satellite locations that are being requested. As far as our cycle time for those satellite certificates, we're covering in just a little under 2 weeks. The corporation certificate, although that total cycle time is around the 37 days, that's largely driven by the fact that we get a significant volume of incomplete applications where they're missing either we don't have the articles of incorporation, or we don't have all the information we need on the corporation. So those deficiencies largely drive up that total cycle time. For a complete application, it's a lot closer to the same number that we're observing for the satellite certificates. And then for the license renewals for the year, the number of Doctor of Chiropractic licenses renewed was a little bit under 12,000. So we're still seeing just that steady decline that we've observed over the past decade. It's not large to the extent that it's putting the board in a difficult situation as far as funding, but we are just seeing just a steady decline over time. Our cycle time for processing those renewals is a little bit over 10 days. For the people that apply that renew through the Connect system, that generally takes 48 to 72 hours, takes about 2 to 3 days to get that done. And then when we're reporting out cycle times for the paper applications, the way that's actually measured is from the point of mailing. So that cycle time on those where it's taking about 12, 13 days. For that also includes 2 to 3 days of mailing time, a couple of days for staff to process the checks, and then to issue the renewals. So I'll get into it a little bit later, but that's one of our major focuses is going to be on the Connect system and trying to drive up the percentage of licensees that are accessing that system, just given that they can automate their renewals in 2 to 3 days. Our corporation and satellite renewals, those are a little under 10 days. So, statistically, they're just about running on that same cycle time as the Doctor of Chiropractic license application. And the next slide. Then looking at our use of the Connect system over the last fiscal year, so we processed a little over 6,000 transactions in that year. What we're really observing is a very high utilization rate for our initial DC licenses. So recent graduates are really interacting with the system. They're creating their accounts early. They're involved in uploading information as they get it and submitting those applications through Connect. We're getting a very low volume of paper applications from our new applicants. Where we're trailing behind and where we need to put our efforts is on the renewal side and our established DCs, getting them to create the account and then access it for their license renewals. We're currently around 30%. Some of the other boards are observing much higher percentages. They're around 70%. And our goal really is 70 to 80% would be ideal for us. The way we go about doing that, we've been working with the department's the Organizational Improvement Office has helped us put together some guides on how to navigate the licensure process. So we're going to be working on getting that information up on our website. We also have, we've also been working and we've emphasized the importance of getting support on mobile devices. Because I know that's been an issue that we've been encountering is the fact that the way our applications are designed currently in the system, they're only working on desktop. People that are using either a mobile device or a tablet are having difficulty be navigating the system. So there's quite a bit of importance on getting that fixed during the next iteration of the project. Next slide. As far as the current priorities on the project, it's enhancing our paper application submission process and workflow. We had set up a kind of a temporary upload feature so that we could easily access any paper applications, could be uploaded, and you can make an online payment through a credit card. That was initially meant to be kind of a transition between you know, having a paper process and eventually building all of those applications out in HTML. Just given the low volume that we get in a lot of our miscellaneous application types, we've been redirecting and we're working on just enhancing that upload and submission process so that licensees can complete PDF applications, upload them, and make their payments. The acupuncture board has developed a cart feature that we think is going to work well for that effort on our side. So they're currently testing their cart feature, and we plan to follow right behind. And what that would do is it would allow licensees or applicants or any member of the public to select different application types, just like if you're shopping in a shopping cart, and then make one payment at the end. Whereas our current system requires all the uploads end up in one bucket, and it calculates the total, but it doesn't allow for us to separate the applications easily on the backside. So we are working on that process. We're also working on implementing the cashiering functionality. They've got that ticket into test. So we've got our DCA accounting team, and then the department's IT folks right now are the ones that are testing that. If it passes their muster, it's going to get passed to the BCE staff, and then we'll test it to make sure that it meets our needs. But the hurdle they have to get through first is getting it passed through the accounting office, because they're the ones that largely put together all of our cashiering functionality. Then we've also been working on the upgrade to the latest version of the Connect software. Unfortunately, the vendor is about a quarter behind, because they had initially promised us that by the end of the fiscal year. Their latest, the latest update we've had is that they're going to have that to us this quarter. So we're aiming for within about the next month to get that up and going. They have a demo, or they're putting together a demo for staff, ideally next week. So we're pushing hard on that, but they are about a quarter behind. Go to the next final slide. And then our other priority, it does relate into licensing, is really getting, after we get upgraded to the new version, the highest priority for us is getting the continuing education module up and running. And we've got a three-phased approach on that. We want to start with the back office application receipt and processing, because currently it's entirely a paper-based process. We don't have any efficient way of managing the applications that are received and tracking, because it becomes paper and Excel spreadsheets. So we want to get that at the beginning phase, get that live in the system. Then we want to, from there, automate our messages and alerts that go to the providers and develop a real-time course listing that licensees can use to search for board-approved CE courses. And then from there, build out the rest of the dashboard to allow for a CE provider to have their individual profile, and then allow the provider to submit applications to the board online, and then also be able to upload their course completion records directly into the system. And then we can sync those with the licensee records that we have. And the long-term goal on doing that is being able to get to the point of 100% audit at the time of renewal, while still automating it to where it's not a burdensome paper process on the licensee. It's just leveraging the data we already have to manually have the system, or to automatically have the system do that audit for us. So there's a lot of exciting things in the way of the Connect system and our business modernization. We're making progress, but there's still a lot to go that we're going to be seeing later this year. We've also met with the Department's Office of Information Services to discuss updating our website, and part of that's going to include updating all of the materials on our licensing processes, and then putting those guides on the Connect system on the website. And once we get all the content where we want, then also following that is going to be updating the look and the feel to a more modern template. So, and then also next week, and we'll get into this a little bit more in the next agenda item, but next week we've set up a meeting with the Office of Information Services to discuss the potential for mobile licenses. It's a little bit new at DCA, but just want to find out and explore a little bit more of what capabilities they have, because there's indications that there's some solutions out there for modernizing kind of the way we do business with licensure. and moving away from a lot of our paper. So a little bit of a mouthful, but we've got quite a bit going in the area of business modernization and IT.
Thank you. That was great. So on the Connect system, are we ready at a place to, I mean, would it be helpful to send out an email blast or kind of recruit CCA to let sort of the current chiropractors be made aware of the Connect system and, you know, how easy it is and with what's coming, you know, down the line? Are we at a place where we can start advertising that for, because not everyone's going to go to the website to check. You know, they'll just get the paper one in the mail and kind of, you know, do the same thing. So I'm just wondering what resources we have or if we're even ready to do that.
I'd say we're very close. We want to make one last refinement to the user dashboard, and it has to do with there's a bit of a disconnect with the way the Connect software displays a license cycle versus the way licensees and even DCA staff is used to normally kind of handling that. So it's reflecting with multiple lines on the dashboard that's a little bit confusing. So we're trying to fix that issue through an ER release, and at the point that we get that fixed, where it's a lot cleaner, you log in and it's just got your Doctor of Chiropractic license with your issue date, your current expiration date, and one button, then we're going to be at the point of really broadly advertising it. So we're very close on that. And then the idea is to send email blasts to our licensee lists and then also get the word out to the associations. And then DCA's public affairs unit can also help us with more of a broad PR campaign about the Connect system and help broadcast that even further.
Okay. And also there's when you first create an account, there's also a separate form that you have to fill out to create the account. Can you talk a little bit about that?
Are you referring to the registration process or the HCAG survey?
What's it called? It's hard to hear.
There's the, oh, I'm sorry. There's the, so to create, you have to, the first step is if you don't have a Connect account, you have to register for the account and then you
Correct.
link your license to that account. So
Yeah,
there's those steps and then there's an annual, it's the healthcare workforce survey that's been implemented, and that's not BCE, that's all the healing arts boards have that survey. So that is for the online tool, that is the first step, and we will make sure that we're sharing that step with everyone so they're familiar with what they're being asked before they can access the renewal.
Yeah, perfect. Okay, because I did it. And I was like, oh,
good.
What's this? So I just wanted to make sure that we let people know. Okay.
Yeah, and then also we'll be watching for that data after it's available next year for future policy discussions.
Okay.
Question going back to the kind of updates that you said that we need prior to communicating out to the wider community about the site. Do we anticipate that being able to kind of hear more about it in the next kind of board meeting in October? Yes. By then we anticipate kind of already having communication out. Yes. Okay. Yeah. It's your timeline. Right? Yeah. Okay. Mm-hmm. Yeah.
I don't know if I interrupted you, Ms. Walker. Was that the end of your update or was there more?
Yep, that's it. Happy to answer any questions.
Okay. I don't, oh, well, I guess why, do you know why that we were up a little bit with licenses issued? Was it just the timing of graduation or because we were like 332 and just up a little bit at 370?
Yeah, it's based on the graduation rate. It was up slightly, and it's actually kind of reflecting what we're hearing from the colleges, because the colleges aren't reflecting, or they're not really relaying any difficulty in enrollment. So it's kind of to be expected. I'm not sure that it's going to be enough to outpace the number that we're declining, but it is. Right. We are seeing just a very slight increase in the number of licenses issued.
Okay.
Actually, kind of going back to the similar table, the licensing population type. I'm wondering, you mentioned earlier that we're seeing an increase now, but it was more of a contraction of we had more satellite certificates prior, and then it's kind of it went down, and then now it's going back up. Is that, initially when I saw this, I was like, oh, I guess the business model in general is changing like everyone else's business model, where, right, people are just going to a more mobile kind of existence in terms of their businesses. Are we seeing, what's it called, since we don't have the prior data to prior years before that, is that what's happening in terms of there was like a cinching during the pandemic of just less satellite licenses and then more going back to a norm? Or would we say that, what's it called? Because I was just looking at the kind of ratio of amount of DCs, right, in the overall population relative to the satellite certificate. Is the data telling us that just the business model is actually changing because we have less DCs and then just more satellites?
We are seeing, so we saw the contraction, we're seeing an expansion, and I would say we're seeing an expansion slightly higher than what we had observed prior to that initial contraction. And we think that that's largely driven by the availability and the increase in the QME examinations, because there's a lot of licensees that, you know, in order to be selected for that exam, they want to be able to diversify and have as many locations as possible so that they're accessible to the patient.
Yeah.
So we're seeing that largely driving that trend, because we're not getting a lot of applications for just one or two. We're getting a lot of applications for multiple, really expanding that out.
Okay.
Great. If there's no other comments by the committee, are we ready? Can I open this up for public comment?
Yeah.
All right, this is the moderator, and I have to ask, are there any,
Yes.
is there any public comment in the Sacramento location?
Not in Sacramento.
Okay, and do we have any public comment in the San Jose location?
No.
All right, so I've opened up the Q&A panel. If any member of the public would like to comment on this agenda item, you may type comment in the field in the lower right-hand corner of your screen, or simply raise your hand. I'll give you a moment. And pardon for the delay, I had to switch computers and the screen's a little smaller, so I'm having to kind of navigate a bunch of different screens. We do have a public comment request from calling user number 2. So remember, you have a 3-minute time limit, and caller and user number 2, you should be able to unmute yourself. All right, we'll try that one more time. Calling user number, there you go, you're unmuted.
So thank you so much for the update for agenda item 3. It's a tremendous amount of progress for all of those items. Thank you. As it pertains to agenda item 3.6 for the college curriculum rule edit, I'd like to ask if it's possible. Yeah, if it's possible to ask if is there a when, like the next significant update will occur for that item? Only because I only saying this because this particular item can be found to be like a delay on it. Does significantly affect it's a human health issue for the delay of it, and if verified that the delay of it does bring harm to the public's human health and welfare, the courts could use that to compel the state agency to expedite that notice for action. So I would like to ask when, and it's just a concern for me that because they got brushed off the table for agenda item 4 and then moved under agenda item 3. That just makes me think that that's like an effort to delay it further. So if that's the effort, like do the courts need to be involved to expedite the issue to prevent harm to the public's human health and welfare? Thank you.
All right, I see no further requests for public comment. Shall I close the Q&A panel?
Yes, thank you.
You're welcome.
And before we move on, I can briefly respond to that time frame. I actually included that in my report. So for the chiropractic college curriculum regulations, those are largely driven by the 2 factors. We have the CCE accreditation standards that are going to be released this fall, followed by the board's occupational analysis of the chiropractic profession, and that new report is expected to be released in early 2024. Specifically, the CCE accreditation standards are essential for the development of this regulation. As I mentioned, because we have to, through our process, we need to identify any gaps or where the board needs to be involved and where the CCE accreditation standards are deferring to boards to make decisions. So until we have that document in hand, we can't come up with our proposal. We also need to ensure that there's a continuum and because we have that interdependence between those standards and our occupational analysis. So we're really looking at early 2024 for that proposal because it's driven largely by those other 2 timeframes.
Thank you, Ms. Walker, and thank you to the public for your question. Staff has your contact information. Again, thank you. Any other comments from the committee before moving on to agenda item number 4?
Ms. Connor?
So I'd like to ask Ms. Brianna Lazier, I'm not sure if I said that right, regarding requirements for filing places of practice with the board and notifying the public of licensure at practice locations and mobile settings.
Good morning, everyone. Thank you for having me. Some of you may know that I work closely with licensed DCs and applicants, so I'm excited to be here and speak on these items. This agenda item contains 2 interrelated components. 1, the filing of places of practice with the board, and 2, a pending proposal to mandate the licensees notify the public of licensure at their places of practice. At the May 2016 board meeting, the board had approved the proposed language found within the attachment of this agenda item. This regulatory text would have required each licensee to display their license in the entry area or waiting area of their practice and display a satellite certificate in the entry area or waiting area of the office at all times while treating, examining, or evaluating patients at that location. The regulations would have also exempted a licensee who is practicing in a mobile setting, such as at a health fair, a sporting event, or a patient's home, from obtaining and displaying a satellite certificate, and instead require the licensee to carry a pocket license and make it available for verification. The regulatory text would also include a mandatory requirement for licensees to provide notice to each patient that they are licensed and regulated by the board, including the board's telephone number and web address, through one of the following methods. 1, posting a notice in an area visible to the patients on the premises where the licensee provides the licensed services. 2, including the notice in a written statement signed or dated by the patient or their representative in the patient's file. Or 3, including the notice in a statement on letterhead, discharge instructions, or other documents given to a patient or their representative. The licensing committee has also been discussing how a place of practice is not currently defined in the board's regulations, and the filing requirements do not address temporary practice settings such as sporting events or fairs, mobile practices, house calls, or consultations at other facilities. Another challenge is that unless they have established a chiropractic corporation, licensees are only required to file their practice address with the board. not the name of their practice, which makes it difficult for the board and the public to access information regarding chiropractic practices. At this meeting, the committee is asked to continue its discussion regarding the filing of places of practice with the board and updating the licensure notification and posting requirements at the practice locations. To begin this discussion, staff recommends defining a place of practice as any location where a licensee practices chiropractic or holds a proprietary interest in related to the practice of chiropractic or any right to participate in the management, supervision, or control thereof. The chiropractic place of practice includes many types of settings. There is traditional chiropractic offices that includes the individual practice, partnerships, or corporation, integrated practice with other healthcare providers such as MD, acupuncture, physical therapists, temporary practice such as sporting events or health fairs, or mobile practice such as house calls, mobile clinics. Staff suggests that the committee considers discussing the possibility of implementing a facility permit for fixed places of practice, such as traditional offices and integrated practices, that contains the name and physical location of the practice along with the name and the license number of each owner, employee, and independent contractor associated with the facility to replace the existing satellite certificate requirement. The committee could also discuss whether to require a mobile permit for practice settings and consider establishing minimum requirements for patient notification of licensure and provide post-care instructions and the provider's contact information to the patient in these settings. Staff further recommends that the committee discuss modern methods to notify the public of licensure at all practice settings, such as posting a QR code that links to the licensee's license or facility permit on the DCA Search Public License Information System. I will now turn this item over to the committee to begin their discussion.
Great, thank you so much. So there's a few topics within this, and I think we can sort of see that from like the second paragraph that she was discussing, that treating, examining, and evaluating patients. So this sort of ties into what we're going to talk about in agenda item 5 as far as inactive or active licensees. So I like the place of practice definition. When I read it, I feel that it's a little limited in the sense of really defining. I feel like, and I want to hear the committee's, thoughts on this as well. Like when I read it and when I hear kind of what's happening, I feel like more of a definition around the practice of chiropractic. There's many things that are included in that. And like I said, this sort of falls into the category of the inactive licensee, but we have examining, we have referring, we have managing, manipulation of just soft tissue, which could be considered, massage type activities. And so I just wanted to start with the definition of place of practice and just seeing if there's more to add to that, if we're happy with that definition, if we see like loopholes with the definition. I don't know if adding something like any aspect of chiropractic and is not limited to. So I think I wanted to start there and open that up to the committee and staff, and then sort of move into how we do that as far as facility permits and those ramifications.
I agree in terms of what's called getting into when we say the practice of chiropractic, of what it is and what it also includes. Where I would say I don't want to say loophole, where, and maybe this is I'm posing a question, is does this definition cover, and maybe it's just how I'm reading it, when, what's it called, the example of integrated practice, if someone is subleasing or you are the leasee versus the leaser, right? And does the definition one capture that? But does the definition also, I'm just trying to also see how the definition captures the mobile practice.
Sure, and I could probably offer a little bit of context because one of the challenges, and it's within the board's regulations at large, and you're going to see that in this discussion as well as actually all of the discussions that are to follow, is we don't have a specific regulation on definitions. So the reason for defining place of practice rather broadly is because it's not only used in the context of filing it with the board, but it's also used in some other sections. So, I mean, one long-term goal, and it probably would be a good item to bring at the October board meeting for discussion, is really around having one regulation with definitions. Just simple as used throughout our regulations. This means this. This means this. It's common with other boards. We don't have one. So that's the challenge, because within this definition where it talks about practicing chiropractic, ideally we would have a definition of what that means that not only applies for a place of practice, but also when we talk about an inactive license cannot practice chiropractic. What do we specifically mean? Because we have the scope where we say what chiropractic is. We don't actually define what the practice is. So that's, I hear you and I agree. I think that needs to be further fleshed out, not only part of this discussion, but the following. The intent behind the language is to capture, when it says any location that they're practicing, it's in all practice settings. It is not meant to include somebody that owns a building that a chiropractor is leasing the space.
Yeah.
But if you're leasing a practice from a landlord, it would include your setting. So that's the only thing it's trying to exclude, is if you're purely a property owner, you don't really have any interest other than get rent for a chiropractic practice.
But if someone owned the building and they were a DC, or they were the, what's it called? They were subleasing a spot, because they're leasing, because we've seen, I feel like we've seen that in other cases where, like, well, someone wants, I was just subleasing the spot and I was doing something else. So I was just wondering if that's also covered.
So the intent is to include them in that. It is to include that discussion if it's like a sublease or if you're renting the idea is that the place of practice is somewhere where chiropractic is either occurring or you're profiting in some way from that practice, aside from just an ownership of a building and the business side of renting the space. And we could flesh that out a little bit further to make sure it's very true. But that's the intent behind it, is that it's whether it's your actual place of practice or if it's a corporation that you own a certain percentage of shares, so you're profiting from the business without actively practicing at that location. We would still want to ideally know that you're associated with it.
Yeah, because I go back, my head goes to liability when we start using that definition of like, okay, well, I'm a DC and I own the building and I sublease to other people, and that person is a little shady. Yeah. Okay.
Yeah, I think to your point, Ms. Walker, like to me, especially with like, more mobile and satellite and less sort of brick and mortar, I feel like the place of practice really, for me, is, what you guys were talking about as far as the leases, subleases, all that, a brick and mortar, but also it needs to, I feel it needs to incorporate wherever chiropractic is happening. So whatever the activities a chiropractor does, whether I'm going to somebody's home or I'm going to a site or I'm doing a locum tenens, those are all, the location per se is irrelevant. It's the act of performing chiropractic in all those individual things. And in my head, that's the definition currently for a place of practice, because it's no longer, brick and mortar as we know.
And that's the intent there around the use of location broadly, is when you talk about place of practice, it's broadly anywhere that chiropractic is being practiced, either permanently or temporarily, even for a day, or also where someone holds an interest in someone else that's practicing chiropractic. If they have a corporation with multiple employees and they have multiple locations, that's kind of the intent there. And then we get into the phrase of settings, is trying to figure out which of, knowing that there's a broad type of practice locations where it's occurring, which settings need to be filed with the board versus, because we would never want a situation where people are filing their clients' home addresses and getting satellite certificates. So that's more of a mobile if you're on the go versus like a traditional, like a fixed place of practice or a fixed setting. that's trying to kind of flesh that out a little bit further, but really trying to broadly define the place of practice. And the reason for doing that is because that terminology is used in other areas of our regulations where we talk about responsibility for conduct at a place of practice or conduct on the premises. We want to be broad enough to where that term is different from, specifically what needs to be filed with the board. And that's where I think we would really also benefit from having just a regulation on definitions at the very first section of our regulation.
Yeah, I mean, from what I'm hearing you say, kind of what I'm wanting is probably more in the regulation on definitions, because I mean, I think I understand what you're saying as far as, it needs to be broad enough to fit into all these categories. My concern is I just don't want to end up with it too broad and then we're left back with, inactive, like without a definition. So, yeah, so my main concern is that it's incorporating enough, but I think I understand what you're saying as far as it needs to be broad enough to fit into those categories. As far as a couple of thoughts on the facility permit, which we talked about, like, I feel like we want to make it easier for corporations and practices, if they have 10 or 12 chiropractors, how do we ensure public safety as a person comes in and say they don't have the information on that person? So I want to talk about the facility permit. And within that conversation, we were looking at the satellite numbers. What would that look like as far as sort of those numbers, as far as satellite certificates and then facility permits? Also, the question in my head is, we have a facility permit and you have it listed. How do we deal with, the turnover rate, say somebody coming and going, and what do we want to have as what's a reasonable time frame? Like you have to notify the board in a certain number of days if you move or name change or whatever. Are we thinking something like that as far as when there's a turnover, they get a new chiropractor, one leaves? How would we navigate that?
Sure. So as far as with the facility permits, I mean, really the intent there is that you identify the person that's really in charge of a specific facility, and then they can, whether they personally file the application or they defer it to staff to maintain that registration with the board. There is that aspect to it of having, the in and out of flow. So we need the flexibility of being able to have that information filed with the board within a reasonable time frame, whether it's 10 days or 30 days, something to that extent. But that also kind of drives into the part of the discussion on the need for potentially modernizing the requirements as far as displaying licenses, because the challenge would really lie in the fact of if we physically print a facility permit and every single time they get a new member of staff or they hire or fire somebody, we have to reprint and mail. I mean, that process in itself takes weeks from when we key in something into our database for it to actually print and arrive. But then it's like, how do you keep it up to date? And so they're all very interrelated, but that's kind of the thought there is come up with a solution where we have some sort of modern license posting, whether it's going, to the DCA search system, because when that gets updated in real time. So if staff keys in that someone's no longer at a facility or that they've been added, within minutes the website is updated. So we'd have to think about how that could work without eliminating the paper and the lag time and just the labor involved in having to print and pay for all of that service.
We've
that
talked
really
about
the intent is to have it be something. Go ahead.
Sorry. We've talked about the QR code. I know a lot of people in medicine are doing that now as for many different aspects of it. I'm just wondering how feasible is that for us? And because to me, I feel like, and you can correct me if I'm wrong, posting a QR code, and then us being able to update it more readily without that paper seems to be kind of the way to go.
And staff agrees with you. That's what we're exploring with DCA's Office of Information Services. In an ideal world, we could have QR codes that directly link to the facility permit, and then probably design it to where some kind of general text that was included in that reg proposal from 2016, just indicating maybe with the board's logo and license, doctors of chiropractic are licensed and regulated by the board, to view the license information about this facility and then put QR code, and then maybe the web address to access DCA search if they don't know how to use the QR code, something simple like that. And we want to get to the point to where for licensees to be able to generate that type of posting requirement, it's a matter of just going into their Connect account and generating it. Like they could just push a button and get a PDF that they can print and put on their wall. So we want to make it as easy as possible and just something that can be just automated so that the licensee accesses it, can print it, put it on the wall, versus that we want to move away from, as much as possible, the automated print services that we're doing because they're costly and they're not very timely. It takes weeks to get that information out to licensees.
Yeah, and I have concerns on the kind of the 2016 kind of language, the second part of it, like, oh, if somebody's in a mobile setting, they would make their pocket license available for inspection, but it's upon request. And I don't, that just doesn't sit well with me. I feel like some people in the public may be uncomfortable to ask, don't know to ask. And so I feel like if there was a QR code that was prominently displayed, it's very easy, for someone to do that. But we also need to have, like the board's website for someone who doesn't have a smartphone. But I feel like that QR code, they can access that very quickly without feeling uncomfortable or embarrassed or knowing to ask. So if we had that QR code for brick and mortar, for satellites that they can, update very quickly, corporations, and then also for the mobile person where they, wherever they go, they just set it out. And then that way the public doesn't have to ask for it.
And to add to that, I see us in like a very kind of quasi-post-pandemic world right now where I feel like it was really the pandemic that got folks really, I would say, starting to get more comfortable with QR codes, especially with kind of the CDPH kind of putting that through with the vaccination records. I can go into the stadium. Why? Because of this QR code, right? And so I feel like it's definitely more accessible to folks than it was 5 years ago. So actually, as we were talking, I was drawing a little grid here. What I'm noticing in the language, at least in how this conversation is happening, is that it's almost, my head works in Excel. So it's kind of, I see a grid. So what I'm hearing is that there is a sense of place, right? Permanent, not permanent, right? And then there's also, you said the word setting, the sense of setting. It's almost formal, not formal, right? And then like in this little kind of grid that I drew, I was like, okay, brick and mortar, someone's in a pop-up tent because they're at an event, someone has their RV, they have a mobile service going for chiropractic, and then they're in their patient's home. And so is it possible to integrate at least kind of that sense of terminology into the definition in some way? Because I feel like that would accommodate what Dr. Daniels is looking for in terms of, we don't want folks to make assumptions on what location means. But I think there's an opportunity to even put place of practice means any location, permanent or temporary, where a licensee practices chiropractic. So even that small language change, I think, would help us here.
Yeah, I agree. Yeah, that's great. I agree.
And the attachment that you gave for this was the proposed language. I think it was from 2016. Like for me, A, B, and C seemed reasonable. I was a little stuck on D, as I said, as far as upon request. I think it should be available just like it is when you walk into my office. It's posted, you can see it. I think it should be the same as far as public safety and comfort. And then when we drop down to the notice to consumers 308.1, and I know this was just suggested language, I was a little concerned. I wanted to hear more, Ms. Walker, as far as kind of the history with this. Like, A seems a little redundant for me. And then the notice to consumers, I feel like it was a little, I mean, there was many options, and the thought that I had was enforcement problems, people understanding, current chiropractors understanding that. It's an additional step. I feel like, if someone is showing you their license, isn't that implied that they are regulated by a board and that they are licensed? And then, I mean, I suppose we could put it on the top of our informed consent form, a statement. So I just wanted to get a little bit more clarification on the thoughts behind that, and like I said, in my brain, I'm just a little concerned about enforcement problems and what that looks like, and if there's any redundancy there.
Sure, and then just a little bit more background information about how this came to be. So it goes back about a decade, but the Consumer Protection Enforcement Initiative originally started as legislation, and it was based on just large reports about issues with all of the DCA boards and ensuring that investigation timeframes are reduced, but then also that public is aware of the various DCA boards. There was a series of proposals, one of which was providing notice to consumers that licensees of various boards are regulated by that board. Where I see it most commonly is within dental offices, but it's pretty standard now that most of the boards, the healing arts boards, have a provision that's about as straightforward as this, where it just simply says something to the effect of notices to consumers. Dentists are regulated by the Dental Board of California with a phone number and email address. I'd say that's largely used as kind of a balance between the profession and consumer access, so that because there had been other boards had discussions of being more prominent, like to file a complaint, contact, and put more information. So it was that balancing act of just making them aware that the licensing board exists. The one benefit for BCE is that we haven't yet adopted this regulation, so we can think about it more modern. And the way I kind of envision it is, if you're moving to the direction of mobile or like posting a QR code, you can integrate these two together. You could put, with that document that gets generated, it could have the board's logo with the notice to consumer to just simply state that, the licensee is regulated by this board. To view the status of the license with the QR code, you can merge the two together. It doesn't have to be two separate posting requirements, because like you said, it would become redundant to have the QR code with access to the license information, then have a separate sign right next to it with a similar statement. So that's a little bit of background on it. this is something that you'll see, especially within medical offices and integrated practices. You'll almost see a poster with multiple different, just 8.5 by 11 sheets of paper with these simple statements, and it's because it's in the current regulation. We've yet to adopt that, but we have now an opportunity to modernize and do something else with the concept.
I've never seen that when I go to the doctor.
Now you're going to look for it.
And I've never seen it
there
at and I've never seen it at the dentist office. But okay.
If I see it in mine, I'll text you.
Yeah.
Take a picture. Show it to me. Okay. So where, just because we have some other agenda items, I mean, where can we go with this right now? And do we need to talk more about the mobile permit? I mean, in my mind, if you have no place of practice and your primary thing is, regardless if it's, I go and I do locum tenens, I cover for somebody, sometimes I go to somebody's office, sometimes they come to me. If I'm kind of all over the place, to me, that's a mobile practice. And I think it should be the same license and the same display license wherever you go. And so in my mind, a mobile person has the same requirements or duties as a brick and mortar. So I guess in my mind, I don't really know why a mobile setting got exempted from displaying your license, and it's only if somebody asks. Any thoughts?
I'd say you're going down the right path. I think it'd be more appropriate that they have to display it in some form. So whether it's that they have to display that same link that anyone else would, or make the information available, like the consumer, how would the consumer even know in those circumstances to ask? Or like you said, it could be uncomfortable to ask. It should be readily displayed. Really the differentiation and the reason behind talking about mobile settings is more based on the filing of like the address information with the board, because under the regs, it's either your license or your satellite is tied to a specific address, and it has to be posted at that address. So that's the part that doesn't work for the mobile setting, because if you're going from place to place and you're pulling it everywhere you go, it doesn't fit within the current regulation. So that's kind of why you're seeing language around what do we do with mobile settings. And then there's different options there of just, you could define in regulation just standards of, what you have to do if you're moving around versus a fixed setting. Or you can go, like some boards have special permits you have to get for mobile operations. I'm likely caution against doing that, and just define what those standards are so it's clear. Because right now there is nothing on what you do if it's a mobile practice.
I mean, doesn't it kind of?
Do they? Oh, sorry, go ahead.
No, go ahead.
No, my question was, for mobile practices, I imagine they still have to file a business address, something, even if it's a PO box, like something, or do we have requirements around that?
Correct. Yeah, they have to file their address of record with the board.
Mm-hmm.
So we have that information, but we don't have we don't have data on the different types of mobile settings, whether it's temporary mobile, you're
Mm-hmm.
advertising your services at the mall and you rented a booth, or if you put together, I've seen a couple that they actually have an RV.
That's what I'm saying.
And you drive around an RV, or if you're going to the patient's home. So none of those are addressed in the current regs.
But we have a business address on file.
Correct.
Like there is a something.
Yeah, we can locate them. It's just we don't have any way of flagging to know that that's the way they practice currently.
Ms.
So
Walker,
whether it's needed or not. Yeah.
I mean, can we address that through the application? Like, you put, your example, RV or whatever, or, you do local tenants or whatever, and you have a list and the person can mark off all the categories that apply, and then that's connected to the address of record?
We could develop something like that, yes. And then you could tie it back to a specific facility or practice. Yeah, we could put that together.
And even the kind of licenses we would require, a pocket license versus a,
Yeah.
Mm-hmm.
Yeah, we could put that together.
Yeah, I mean, because that way they can, we leave it to the licensee. You tell us what you're doing, which categories, we get a list of them. And maybe they do multiples, maybe they just do one, maybe they just go to people's houses. And then we can start getting metrics on really what that looks like.
Yeah.
So do we want to make a motion as far as this place of practice definition currently and adopting that, or moving it forward, or does staff have enough information to sort of address the committee's concerns?
I'd say that we've got plenty of feedback and direction, so thank you from the committee today. We'll bring it back to a future meeting with a little bit more concrete. It's not something that we need a motion on right now, but we're going to take all of the committee's feedback and then come back with an updated proposal for discussion.
Okay, yeah, and then I think the full board would, I mean, obviously we will, but I think the full board would, also kind of want to see what those definitions are and what that looks like, and have some input on that as well.
And we can share the definition with the kind of modifications made by the committee's feedback during the update at the October meeting, but it doesn't have to present yet as an action item, just as an update item.
Yeah, I think that would be great, getting them like sort of thinking about it and like where we're at, what we're trying to do with it. I think that'd be good.
Okay.
Okay. Any other comments before I open it up for public comment?
One last comment now that we're talking, I just saw in my notes. when just as staff looks into kind of the definition and also looking at like fixed places and facility permit discussion as well, we might want to talk about, I'm not sure if it's included, but kind of to your point with the RV, would an RV be considered as a fixed place of practice? Right, so and we're going down that road. So
yeah.
might as well. Okay.
Okay. Yeah. Well, yeah, we'll have that captured in when they're identifying their business model.
That's it for me.
Okay, great. Moderator, can you open this item for public comment, please?
Thank you, Madam Chair. I've opened up the Q&A panel, and as I do that and give our online participants time to access it, do we have any participants at the Sacramento location?
No participants in Sacramento.
All right. How about San Jose?
None here.
Okay, thank you. And I do see we have a hand raised from our online attendees. One moment, please. All right, so we have a attendee named Marissa. Marissa, you should be able to unmute yourself. There you go, you're unmuted. Marissa, can you hear us? Oh, looks like she got muted again. Let's try that one more time. Marissa, you should be able to unmute yourself. There you go.
Can you hear me?
Yes.
Okay. I'm not sure if this applies to this agenda, but if you guys are open to it, if there could be a category separating a mailing address from a practice address, that would be very helpful.
All right, and I see no further requests for public comment. Oh, wait, we have a hand up again. I'm sorry, Marissa, were you not finished?
No, did you guys hear what I said? I'm sorry. Could you hear me?
I could hear you, yes.
Okay, I'm sorry. It's just as long as somebody heard me. Thank you.
You're welcome. All right, I see no further requests for public comment. Should I close the Q&A panel?
Yes, thank you.
You're welcome.
Thank you for your question. And you can give the staff your information so we can contact you. And I believe that's addressed in one of those regulatory packages, Ms. Walker.
We have the pending regulation that's going to establish your address of record, and then if the address of record is a PO box or private mail service, then they have to provide an alternate physical address. And that's also, thank you to the attendee for sharing that comment, because that could be something that we incorporate when we talk about putting together a facility permit. If a physical mailing address for the facility is actually separate from where the practice is taking place, we could explore that a bit further offline. So thank you.
Yeah, perfect. Thank you. Well, let's move on to agenda item number 5. And this is review and discussion, possible recommendation regarding the requirements and limitations for inactive licensees. And Ms. Pitto, can you give us an update on that?
Of course. Good afternoon, Dr. Daniels.
Hi.
So a little background on this. The Business and Profession Code Section 700 establishes an inactive category for health professional licensure, which is intended to allow healing arts licensees who do not actively practice in their profession to maintain licensure in a non-practicing status. And then Business and Profession Code Section 702 prohibits an inactive licensee from engaging in any activity for which an active license is required or representing they have an active license. So currently, our board licensees with the inactive license are exempt from the board's continuing education requirements. However, all the other requirements are the same for those with an active license. So inactive licensees must renew their license annually and pay the same $336 renewal fee, provide their mailing address to the board, and disclose whether they've been convicted of any crimes or had any disciplinary action taken against them in the last renewal period. Then to reactivate an inactive license, licensees must complete an inactive to active status application. They have to pay the annual license renewal fee and provide proof of completion of continuing education equivalent to that of one single license renewal cycle. The board's regulations do not allow licensees to restore an inactive license from forfeiture or canceled status. Instead, licensees must complete the application for restoration, provide documentation to satisfy the continuing education requirements, and pay $672 restoration fee. On February 24th, 2023, the committee discussed how the phrase "not actively engaged in the practice" within Business and Profession Code Section 700 is vague, and the potential need to establish regulations to clarify the prohibition against engaging in any activity for which an active license is required in Business and Profession Code Section 702. So at this meeting, the committee is being asked to continue its policy discussion regarding the requirements and limitations for inactive licensees and the potential need to developing regulations regarding the activities that require an active chiropractic license and provide direction to staff. So with that, I'll turn it back over to the committee for further discussion.
Thank you.
Thank you.
I have some notes, but Ms. Cruz, do you have any comments or?
Let's see, for this section. No, I feel like this is definitely going to be in more your wheelhouse.
Okay. So, you know, the first question I asked to myself was like, is this an issue? And the issue being, we don't really have a very clear definition of inactive. I mean, when I read it, it's quite obvious. And in my head, I wouldn't do anything that I'm doing right now. And I think this partly came up because of my concern for true inactive licensees on say a retirement income. And the question came up where I wanted a survey to the licensees about reducing that fee, absorbing the cost by active licensees so that we can keep those members a part of our community. You know, someone who's not practicing at all, maybe teaches a little bit or just doesn't do anything, just, you know, is a consults occasionally, but is not performing exams, is not referring for MRIs, is not doing any diagnostic physical exams, imaging, management plans, evaluating progression, you know, any of those items. And so at least for me, that's where it sort of came up. And then it was suggested that perhaps things are happening with inactive licensees that really fall under what an active licensee. So regardless of if it's happening or not, I think it's good to define what we mean by inactive license so that we have a clear understanding of that. And so when we read it, it says in which any activity which an active license or certificate is required. And if you actually just Google what that is, there's a whole list of what that means. And some of them I listed off. So performing an exam with a diagnostic interpretation, making recommendations for imaging, monitoring patients' progress, manipulation of soft tissue, etc. So I just like to have that discussion as far as what we, you know, do we want it to be more clear? I mean, I think it should be more clear, but I want to hear what staff and committee think and how we would go about that, you know, in regulation and legally. And then the other is, in my head, I'm not understanding why to reactivate an inactive license only requires a single license renewal period. So maybe I'm misunderstanding, but if I'm inactive for 5 years, my understanding when I read this is, oh, I'd only have to do 1 year of CE to get my license back. And I think that is hugely problematic because we don't let other people do that, who, you know, in other situations, and I know enforcement is talking about how many years of CE, passing the MBCE, the law exam. So I'd like to really have a conversation and maybe some history behind why maybe I'm misunderstanding it or why it's only a single year to go from inactive to active. Because I mean, if I go inactive for 5 years and then I just have to fill out 1 year of CE, I don't know if personally I'd be like, oh yeah, I'm ready, unless I was like engaging in the community somehow. So those are kind of my thoughts and where I'd like the conversation to address.
Sure, and I'm going to actually respond to the last point first. It's the reason that you can reactivate a license with just a single year of CE, whether you've been inactive for 1 year, 2 years, 20 years, is driven by the language that's in the statute. So that's the Business and Professions Code Section 704, Subdivision B. That's the way the legislature put that program together. If we have concerns of that, especially as we get into exploring regulations and further defining what it is you can do with an inactive license, we can always bring those concerns to the legislature as part of our sunset review and ask them to maybe consider or rethink or, you know, change it for chiropractic licensees, because if we've got a compelling need that we need to change it. What the inactive license really does is it allows you to kind of to keep that door open so that you're not subject to your license going into cancellation and having to either, you know, take a lot of CE or pass some sort of competency exam to reactivate it. So that's largely the history behind it. It's just the purpose really behind the inactive license is just for you to maintain it so that when you do wish to re-enter the profession and use it again, it's relatively simple for you to get back, because otherwise we would just have a large population of licensees that just let them go and don't even maintain licensure. Staff agrees with you that the problem is within the statute itself, the language is very vague, because it's just, it's that language that we have in the meeting materials, but where it talks about you shall not engage in any activity for which an active license is required. That's not specifically addressed in our regulations anywhere. There's a general understanding of what the practice of chiropractic is. If it's an enforcement matter, we would have to get a subject matter expert to opine on whether or not something's the practice or could be performed by someone without a license, so that we could prove that someone is practicing chiropractic on an inactive license. We could go a step further and putting it clearly in regulation. Either, you know, we can work with our legal counsel on how we would actually draft that, whether it's we draft prohibitions, like if you have an inactive license, you cannot, and then make an entire list of the things that qualify as practicing chiropractic, or you could go on the reverse and you could define the practice of chiropractic includes blah, 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 and then have language that clarifies that an inactive license shall not perform any active chiropractic as defined. So we've got some strategies there, but I think it's definitely an opportunity for us to look at regulations, just given the fact that we don't have we have a need to further specify what it is you can or cannot do with an inactive license, just given that we know that there are those kind of evaluations that are being performed by inactive licensees.
So is it something like you had mentioned that regulation on definitions? I mean, is it something that we can create a regulation on definition of what that means and keep what it says, but then attach a regulation to that? Or is it sort of the whole thing has to go through the legislative process?
So we have to go through the regulatory process either way, but it's more of a matter of being able to use and leverage language in multiple sections. If you define it, if you have a clean just set of definitions and understanding of what terms mean, you can then cross-reference them in your regulations versus having to, what we're encountering now is that the OAL standards for regulations are much higher than they were when the board adopted a lot of the existing regulations they have, you know, in the 80s or the 90s. So every time we want to make a change, we're confronted with having to define all the various terms that were already in existing regulations. So it actually fits broadly into our strategic plan objectives to kind of clean up our regulations. One way of doing that is just clearly defining them at the beginning. And that's probably a strategy that could work here, is if we define what the practice of chiropractic is or what it includes, then you could have a separate regulation that talks about, for purposes of like define what an inactive license is and that they cannot perform those services as defined. So we've got strategies there that we can work with our council to put together.
Okay. I was just seeing if I had any other notes on that. Any other comments, Ms. Cruz?
None for me, but I appreciate the context that you to help me understand further this particular agenda item, that I can see, especially as we get different cases come by and we hear about we see folks getting into more of a consulting role, right? With what's it called, without a license, then I can see where it gets very gray.
Ms. Fokker, it also makes me think of, I mean, I don't know if this relates, but if we define what inactive can and can't do, I don't know if that spills over to, there was a public comment a couple meetings ago on a licensee, a revoked licensee working in a chiropractic office, and what they can and can't do. And so I don't know if that sort of spills over into that topic of, sort of defining more clearly what it is you can do with an active license or what you can't do. And so I think of that particular situation, someone whose license has been revoked, and like I said, they're working in a chiropractic office, and, I feel like it could be confusing for the public. Like, so we have the QR code, but are they looking to see that it's inactive? Like, it's like you flash something and they're like, oh, they have a license, right? Like, is the public going to assume or know that if they have an inactive license that, oh, maybe they shouldn't be performing these duties, right? So I think of sort of the stakeholders and the difference between the licenses and what's showed to the public, I guess is what I'm trying to say.
Sure. And what comes to mind with that is, so on DCA search, it does tell the public whether a license is active. Like, I think it says valid or it says inactive. I think it says valid, inactive, and it has a little bit of a definition if you hover over it. Okay. One way we can kind of really ensure that and kind of tie it into the discussion we had on the prior agenda item is, depending on which link is in the QR code, if it's linking to a facility permit, we can establish methods to where if you have a facility, like there is no circumstance where you have a facility permit and an inactive license, because the two aren't consistent with each other. So we can ensure that if you move your license to inactive, you no longer have a facility permit. So if you were trying to display an old QR code, you're gonna have a broken link. It's gonna show that it's no longer valid. So we can fix it that way and not let people create new ones. So we can actually better control it by moving to QR codes versus paper licenses.
Yeah, I think that would ensure a little bit more sort of public protection or sort of awareness. I know topics like that have been brought up from the public as far as having more information about the licensee.
Yeah.
As the camera person, I keep going like this, thinking that I'm going to see Ms. Walker more. Oh, there you are. Like, doing this is not going to do anything, Dan. Okay, thank you. Okay, so are we okay for opening this up to public comment? Moderator, can you open this up for public comment? There you are.
Thank you, Madam Chair. I've opened up the Q&A panel, and I must ask again, do we have any public comment from the Sacramento area?
Public Assemblies of Sacramento.
All right, any public comment from San Jose?
No.
Thank you. And I will give our WebEx participants a moment. If you'd like to make a comment, please raise your hand, or you may type comment using the Q&A field in the lower right-hand corner of your screen. I'll give you a moment. All right, I'm seeing no requests for comment. Shall I close the Q&A panel?
Yes, please.
Okay.
Okay, and before we move on to agenda 5, Ms. Walker, I feel like we have enough sort of in this conversation to start strategizing with legal and coming up with some options. Is that what I heard?
We do, yeah. We have what we need to start putting a more concrete proposal together for the committee's discussion. And then also to your latest point, we'll have a little bit of collaboration between this committee and the enforcement committee when you talk about the practice of chiropractic and what can and can't be done, because we've got some room for overlap there between this effort and updating section 312. So we will update both committees and have that kind of broader discussion at the board as well. So we've got what we need to put a proposal together. I think when we go back to definitions, there could be some overlap. So maybe both committees need to weigh in on the actual definition we come up with.
Yeah, I think that'll be good. I think it'll take a little sort of noodling and massaging of redundant terms, highlighting what's really important, what's significant, without being overly prescriptive. Okay.
Yeah, so we'll plan to bring that to the board as well.
Okay, great. So I think we're on number 6. Thank you. Okay. So we were just going to start a conversation on a recommendation regarding the practice of chiropractic through telehealth, and the staff has put together a really good package on kind of some different terms, what the acupuncture board is doing. So Ms. Brianna, can you give us an update?
Yeah, so to summarize that item, during the May licensing committee meeting, the committee expressed interest in discussing the practice of chiropractic via telehealth. The issue of practicing chiropractic via telehealth was last considered by the board when developing its 2021 Sunset Review Report. At that time, the board noted telehealth is becoming more widespread in healthcare professions, including chiropractic, and its use was accelerated by the COVID-19 pandemic. While the hands-on aspects of chiropractic care cannot be provided via telehealth, it can often be used for patient consultations, follow-up visits, patient education, and health and wellness coaching. The board has not adopted any regulations related to telehealth. However, the licensees must comply with the provisions of the Business and Professions Code, Section 2290.5, when providing telehealth services. They are subject to the same standards of the practice while delivering in-person patient care. This statute requires healthcare providers to inform the patient about the use of telehealth and obtain verbal or written consent from the patient for the use of telehealth as an acceptable mode of delivering healthcare services and public health before the delivery of healthcare via telehealth. Providers must also document the patient's consent. The California Acupuncture Board is currently developing a regulation to establish standards of practice for practicing acupuncture via telehealth. Among other things, the regulation would include the factors that licensees must consider when determining whether their delivery of acupuncture service via telehealth is appropriate, such as the patient's diagnosis, symptoms, and medical history, the nature of the services to be provided, including anticipated benefits, risks, and constraints via telehealth, and the licensee's ability to deliver such services via telehealth. Also, the California Board of Occupational Therapy and the Board of Behavioral Sciences have established standards of practice for telehealth through regulations, and some chiropractic boards in other states have similar standards. For example, Texas has established requirements for telehealth that are generally consistent with those found in the Business and Profession Code, Section 2290.5, while Florida has created a more robust regulation requirement for out-of-state practitioners to be able to perform telehealth for Florida patients. Examples of those requirements can be found within the meeting materials. With that, I'll turn this item over to the committee to begin their policy discussion.
Okay, great. Thank you. So thank you for grabbing the Florida one, because I had stumbled upon that when I was looking up some reciprocity stuff and then realized that I didn't think that we had something for telehealth. So I mean, I really like the acupuncture board's proposed language. I think that while I love the out-of-state certification that Florida has, which I think is great, but I'm just concerned, like, how would we enforce it? You know, what is the cost of that? So I have questions sort of around that. And then in addition to the documents that are provided, I had gotten some information on telehealth documentation requirements, and I cannot speak to say if this is required by medical. I believe I got it from a medical documentation requirements. And I can forward that to Ms. Walker, but there's, in addition to informed consent, there is they require like getting location of all parties, names and roles of all participants, and start and stop time. So they're kind of moving away from, I spent 15 minutes with this person. It's really, I started at 12:05, I ended at 12:30. Chief complaint, the consent, history exam, and then what you can get via FaceTime are like to document skin tone, breathing, color, have them move around, have them move the camera around, have other people there, if they have pulse ox, so gathering some vitals, height and weight, and again, we're not weighing them, but that is in our regs as far as our, brick and mortar. So I do have sort of that document that, I can share, and we may want to sort of feather into the conversation as far as what we want that to look like. I don't think we want to make it overly prescriptive, but at the same time, what are the consequences for public safety and public health? And, what does that look like? I don't know if we've had any enforcement issues with it. I don't think we want to wait for one. So those are kind of my thoughts. I'd like to turn it over to you guys and see what you think.
Do you have any questions on this one?
I think where I was going to go is more around, because I was listing out the different categories of focuses across all of them in terms of security, information security concerns, making sure you get the consent ahead of time, and then even getting into how do you ensure kind of what's it called, disclosures around disruptions, but kind of the more Dr. Daniels goes into it, I'm like, yeah, there's a whole different slew. I think that was definitely going from a patient experience perspective versus what's it called, actually an operational enforcement perspective.
But Ms. Cruz, I mean, that's like what we want to hear, like it's valid, like, as a patient, you're sitting there, what are those concerns, and, what is reasonable for the licensee to do? Like in one of them, it said to show your license at every single telehealth meeting that you have. I mean, I don't know if that's redundant. Again, it's walking that line with, Ms. Cruz, you're as a patient, what do you need to see? you know, do you need to see the doctor's license and you've met them 5 times before? What are your concerns? You know, if something happens, how do you follow up? So I think those points are very valid.
Yeah, because even even my own experience with telehealth, right? Of just what's it called, getting kind of either response messages through an encrypted kind of type methodology, right? So that way there's a direct opportunity to communicate with them. Even the kind of having access to kind of the summary of details, right? Post appointment, knowing that like one is in a secure location, right? And it's not necessarily going to my personal Gmail account, right? But also that they heard me and it is what I expected to be documented was documented, what I shared. And that, I think to your point of kind of showing the licenses, I feel like there's definitely opportunities around that in the options I feel like we were talking about of like any communication afterwards to include a certain language. I think there's opportunities there. I think where I may be concerned as a patient is the documentation of what that includes and does not include, right? So this is me just being a little silly and of saying like, you know, I'm not being guided into a manipulation, right? Like you're not going to show me how to do one on myself, right? Like that's not what we're talking about, right? So even just the description of what the experience is not going to be, right? Especially when someone is traditionally used to a chiropractic kind of consultation in person. So just from the patient perspective, knowing up front what this is not right now. I like the acupuncture board of knowing up front, we may lose connection, we may lose Wi-Fi, right? Acknowledging there may be disruption, but also the acknowledgement of this is not going to be your what's it called everyday chiropractic appointment, right? And just being able to understand what I'm walking into and what it's not going to be, and if I wanted a different, if I have to have a different understanding of the services I will experience through telehealth, right? Then I have to acknowledge, I have to engage in a different mode, if you will. So I would say that clear delineation from a patient perspective is extremely helpful.
Yeah, that's great. I mean, I like the acupuncture board. I thought it was pretty thorough, but you made me laugh when you said doing a self-adjustment. There's actually like you can walk you can actually walk somebody through like doing an Epley's, you know, for vertigo, and there's something called a snag, which is a sustained apophyseal adjustment, which we actually have people do on themselves. It's not a high velocity, obviously, but
yeah. But you see what I'm saying? Like there's a fine line where people like there's right where there's opportunity for risk.
Yes. Ms. Walker, any feedback?
I'd say that, well, so in terms of, I agree, from the staff perspective, we have not been receiving a high volume of complaints that relate specifically to telehealth treatment, but that doesn't mean that we have to wait. We do really like the acupuncture model, and it's pretty closely related to chiropractic in that, you know, got chiropractic adjustments, you have needling, but how do you encounter the telehealth world? I think a lot of their language is reasonable. I really did like their bullet points in the meeting materials around the factors that you have to consider on whether telehealth is appropriate for that visit. And particularly, I really liked the language around ensuring that the licensee is competent to deliver those services through the knowledge, skills, and abilities to be able to deliver that through telehealth, because it really puts the onus, it's already implied when you talk about the standard of care, but just putting it right there in language, I think is very helpful. So I really liked that language they've really been putting together. And like you said, it's not an enforcement matter right now, but that doesn't mean that we can't further define and, you know, help public safety by just putting it into regulation. So it's a good discussion. I think I agree with you on the model.
And before I forget, like the Florida one or just the out-of-state telehealth, it just made me think of reciprocity issues and enforcement issues. And does that take us down to what you can do in California versus what you can do in Florida? So I forgot I had highlighted that in the standards of practice for the telehealth. You know, because it says lawfully provide services in that jurisdiction. And so that might be a phrase that we wanted to add to the acupuncture board, you know, sort of profile as far as making sure that we're covering scope of practice. I mean, I think it's fine, but just something to consider.
Yeah, we can add further clarity on that. I would say the Florida model is rather unique. It's pretty broad because it includes all the different healing arts and how you can register for an out-of-state practitioner. I'd really caution against trying to go too far down that model without involving the legislature. That's a big undertaking. But there are some things we could borrow there. And then what stands out that I don't think, unless I overlooked it, the acupuncture included, but the other boards have, is they really define, when you're talking about the practice, they're talking about the patient's location. So, so it's like if you have, you know, a Nevada chiropractor physically located within the borders of California, but they're treating a California patient, they need to be licensed here. But what do, you know, if the patient's located in Nevada with a California chiropractor? So we can further clarify that within our regulations as well, because that question comes up quite a bit just with people contacting the board. Like, well, what do I do if, you know, the patient versus the chiropractor's location? Where's our jurisdictional bound? So we can explore that a little further.
Yeah, and vice versa. Like, where is the doctor? Where's the patient? And vice versa as far as the state goes. Yeah.
Yeah. I feel like I have a operational question. I'm assuming there are billing codes already in place related to what's it called, telehealth, and we don't get involved in any of that. So I wasn't sure. I'm not sure how billing codes for that stuff work. Dr. Daniels would know better than me, but yeah, there's all the standards for documentation to support billing, and I think they incorporate. I don't know if it's separate or with telehealth visits, or if it's just you have to meet the same components.
Yeah, there's a different billing code. I mean, I can get it to you, but
oh no, I just want to know. Yeah. When I was reading through what's it called, Florida stuff, and it was talking about billing codes, and I was just like, wait, so is this treated differently? Because if we're gonna further define it, if there's gonna be differences in the regulations, is there differences in the billing side, and there as a result, is it then treated differently by what's it called, the licensee? So I was just trying to understand, like, okay, there's clearly going to be a defined difference here. Is there anything more we have to do on the other side of things, kind of thinking about the full chain of events when someone engages in telehealth?
Well, and I think, Ms. Cruz, it's where I got the telehealth documentation requirements, was that you needed these items to support the particular billing code for telehealth. Now that you're saying that, I think that's where I got it. I texted it to you, Ms. Walker, as far as just as a draft, but I think that's where I got that from. You need those points and documentation to support the billing code for telehealth. Mm-hmm. Okay. So this was just, I think, just sort of an introduction, sort of saying hi to it, seeing what we have there. Any other comments before I open it up for public comment?
None for me.
Okay. Moderator, can you open this up for public comment, please?
Thank you, Madam Chair. I'm opening up the Q&A panel, and as I do so, do we have any public comment from our Sacramento location?
No, nothing in Sacramento.
Thank you. How about our San Jose location?
No.
Thank you. All right, so I'm looking. Our WebEx attendees can either raise their hand or type comment using the field in the lower right-hand corner of your screen. All right, I'm seeing no requests for public comment. Shall I close the Q&A panel?
Yes, please.
Okay.
Anything before I open agenda item number 7? Just one last call. Okay. So at this time, I'd like to open it up for public comment for items not on the agenda. The committee may not discuss or take action on any item during this section, except to decide whether to place the matter on the agenda of a future meeting. Moderator, yeah, great, thanks.
Thank you. And again, I'm not forgetful. I'm required to ask, do we have any public comment from our Sacramento location?
No.
Thank you. And how about San Jose?
None here, thanks.
Thank you. Let me make sure I open up the Q&A. Yes, there it is. And I do see we have a raised hand from Marissa. So Marissa, you should be able to unmute yourself. And Marissa, yep, we can hear you.
Okay, thank you. For something to consider to talk about at the next licensing meeting, especially if you guys are doing definition regulations as well as looking at defining scope, if you could add including regulations for the board to regulate certified and trained animal chiropractors in the state of California. That's all.
Thank you. All right, I see no further requests for comment. Should I close the Q&A panel?
I think one just popped up.
Oh, thank you.
Mm-hmm.
Call-in user number 2, you should be able to unmute yourself. There you go, you're unmuted.
Hello, this is Falcon again from LifeQuest. I'd like to request that the rule edit for section 331.12.2 involving an allowance for a partial point toward college graduations with the student intern at clinic for the evaluation that includes the detection of subluxation with measurements, with data that has an indication of no presence of subluxation and therefore warrants no need for a subsequent adjustment. Since it's not an official agenda item for this meeting, if you could return it as an official agenda item as soon as possible, just because I just fear that it went from 4 to under 3. And then I fear that it might go deeper into that if I didn't request it to return to an agenda item on the phone.
All right, this is the moderator. Was that all, calling user number 2?
Yes, thank you.
Okay. You're welcome, thank you. All right, I see no further requests for comment. Shall I close the Q&A panel?
Yes, please.
Okay.
Again, thank you to the public for your public comments. And at this time, I would like to open it up to the committee for future agenda items. Ms. Cruz?
I have one item, but it's specifically for the governance committee. It's just what's it called? Any communication updates that go out to the wider, let's say, chiropractic community, or because I know we had mentioned something about, Dr. Daniels had mentioned communication going out of kind of announcing the system.
And then, thank you. And I believe sort of all my future agenda items have already been listed. So just continuing forward with those, which includes one of the public members, and at some point starting to look into the public comment on the scope question. I don't think that will, I think there's a lot to do, but putting that on the agenda at some point. But I think we already have our list. Is that correct, Ms. Walker?
That's correct, yeah, and we'll add those additional items to that list.
Okay, great. All right, any other comments before we adjourn?
In here.
And make a motion to adjourn.
Oh, wait, we'll want to open it for public comment
Public comment.
on
Sorry,
future agenda
thank
items,
you.
then we can adjourn.
Okay. Moderator, can you open up for public comment again?
Thank you, Madam Chair. I've opened up the Q&A panel as people may type comment in the field in the lower right-hand corner of the screen or raise their hand. And as we wait for that, again, one last time from Sacramento, any public comment?
And in Sacramento.
And San Jose?
None here.
Thank you. All right, and I am seeing no raised hands from the people in WebEx. So shall I close the Q&A panel?
Yes, please.
Okay.
Okay, so it's 1:06. Thank you, everybody.
Thank you.
Thank you.